Good day, Namibia, and welcome back to the Government Information Center. My name is Angela Situmbeko, and I will be your host for today. Our topic today will be the types of labor disputes and processes. So the topic aims to create public awareness on the different types of labor disputes and processes. Grievances and conflicts are an inevitable part of the employment relationship. The objective of public policy is to manage conflict and to promote sound labor relations by creating a system for the effective prevention and settlement of labor disputes. A key objective of effective systems is to ensure that wherever possible, the parties to the disputes manage to resolve the issue amicably. So today in studio, I am joined by Ms. Kailiki Sihlahla, who is the Deputy Labor Commissioner at the Office of the Labor of the Commissioner, as well as Ms. Mr. Luella Sasele, who is the Acting Deputy Director at Conciliation and Arbitration at the Office of the Labor of Commissioner, as well as Ms. Betty Amunyala, who is an arbitrator at the Office of the Labor Commissioner. Welcome in studio. So today, once again, I reiterate the topic is the types of labor practices, the types of labor disputes, and processes. So we'll start with Ms. Sihlahla. What is a labor dispute?
Okay, thanks very much for the question. A labor dispute is a disagreement between an employer or employer organization on the one hand, and an employee and the trade union on the other hand. And that is now regarding the terms of employment. And such disagreement may emanate from the rights that are enshrined in the Labor Act or the rights that are stipulated in the contract of employment. So in short, that is what a labor dispute is all about.
Okay, and what types of labor disputes can be referred to the Labor Commission, Mr. Salha?
Okay, the labor disputes that can be referred to the Labor Commissioner, like I said earlier, we've got disputes emanating from the conditions of employment. That is now what is stipulated in the Labor Act. And also the contract of employment, for example, it would say, you are employed in this position and your salary will be, for example, 5,000, and you will be working from 8 to 5, and you will be getting a lunch break, and then maybe you will be required to have also some times off. You are entitled to have like a compassionate leave and so on. And you will be also receiving some fringe benefits such as medical aid, contribution to JIPF, or transport allowance, you name them, or car allowance, etc. And now, once there is a violation of those rights that are enshrined there or stipulated in your contract, then a dispute that will arise from there will be then regarded as a dispute of right because your rights have been violated. And then you have got also a dispute that will emanate when parties would want to negotiate on new conditions of employment or new rights. Then if you do not reach an agreement, then what you will refer is a dispute of interest. So, in short, those are the types of dispute that we normally receive or the Labor Commissioner receives.
Okay, so that meaning that two types of dispute is a dispute of right and a dispute of interest.
Yes, sir.
So if we could go to Mr. Sasele, could you kindly just go into detail as to what exactly is the difference between a dispute of right and a dispute of interest?
Right. First, I would like to state that it's very important for the parties to know the two different types of disputes that were just mentioned now by the Deputy Labor Commissioner, in order for them to know what type of dispute to refer to the Labor Commissioner. as she has indicated that there are two types of labor disputes. A dispute of interest is defined in the Labor Act, in Section 1 of the Labor Act. And it states that it's any dispute concerning a proposal for a new or changed condition of employment. But this should not include any dispute that the Labor Act or any other act requires it to be resolved by adjudication in the labor court or any other court, or to be resolved through arbitration. So in simple terms, a dispute of interest, it is a claim that is made by a party to something that is new, something that a party is not entitled to. Just to give an example is the wages of the following year. No, a party is entitled to the wage that you are receiving that particular year, or at that time, because that's what is being agreed upon. If you want it to increase, it must be negotiated. That is a dispute of interest. Whereas a dispute of right, it is a claim that a party to an employment, to an employment relationship, that a party is entitled to. And this, where do they get the entitlement? They get the entitlement from the employment contracts, collective agreements, statute, or even common law. An example of this is leave days, vacation leave days. So if in your employment contract it says that your leave days per annum, this is vacation leave days per annum is 20, you have a right to that claim because you drive it from the employment contract.
Okay, you have made it quite clear, Mr. Sasela. But just as a follow-up, what type of labor disputes does the Labor Commissioner usually receive?
There are many different types of labor disputes. But the most common one is like on terms and condition of employment. Terms and condition of employment, it can be both right or interest dispute. I will just give an example of leave days. If what is in your employment contract, this is what you have agreed with the employer, is that per annum you'll be entitled to 20 leave days. Then the employer unilaterally decided to change it without consulting you. So it will be a dispute, that will be a dispute of right, and it will be known as unilateral change of terms and condition of employment. And for dispute of interest, like if you want to improve on what is already there, if 20 days vacation leave is what you have agreed with the employer, you want it to be increased to 25, you have to negotiate. Such a dispute, it will be known as, it will be a change for, it will be a dispute of interest, because you are trying to create, or you have referred a dispute on something that you are not entitled to. Some of the common types of dispute is unfair discrimination. All the employees, they have a right not to be discriminated at the workplace. So if you feel that you are discriminated, you have a right to refer such a dispute to the Labor Commissioner. The employees also have rights not to be unfairly dismissed. There must be a valid and fair reason to dismiss an employee. And a fair procedure should also be followed. If these were not followed, then an employee have a right to approach the Labor Commissioner to refer a dispute of unfair dismissal. There are many disputes, such as the payment of leave days. If all employees, they accrue some, if you did not use all your leave days during employment, depending on the contract of employment, when you leave employment, the accrued leave days, or the leave days that you did not use, but it have to depend on what the contract of employment say. They have to be paid to you.
Well noted. But sticking to you still, Mr. Sasele, when does a labor dispute arise?
A labor dispute arises when all internal processes have been exhausted. Maybe someone will ask, what are those internal processes? Just to give you an example, if any employee is dismissed, if is dismissed today, does not mean that a dispute have arose. You have to go back and check what it states in the employment contract. Some of the employment contracts, there is a provision that when you are dismissed, you must appeal. First, you must appeal before you refer a dispute to the Labor Commissioner. If you did not appeal, then you will say that the internal processes is not yet exhausted, meaning that a dispute did not yet arise. It will only arise when all these internal processes have been exhausted. You cannot argue with the employer. After arguing with the employer, then you claim that you were dismissed. At least you should try to have proof that I was dismissed. You can even request the employer to put it in writing. But there is no law that says that a dismissal should be in a written form. But just to avoid arguments, to avoid disputes, if it is put in writing, then it's fine. So now, all employment contracts, because some of the employees, they don't have employment contracts. But like for unfair dismissal, it is very important that whenever an employee is not happy with the employer, you cannot at that time approach the Labor Commissioner that there is a dispute. You should approach the employer. If you were not paid that month, approach the employer and ask the employer, why I was not paid my salary for this month? Only when the employer have refused. And if there are some internal processes, you must exhaust those internal processes. You must follow them.
So in short, so basically a dispute can only arise once the internal processes have been exhausted, and for example, you have a contract that was not followed, then it's possible for the dismissed employee to follow up with you now.
Okay, I would like to just add to what he has said, that the Office of the Labor Commissioner is not there to hijack the internal processes within any given organization. If, for example, an organization has got procedures to say once you have been dismissed, you have got the right to appeal the decision of the disciplinary hearing. You cannot just receive your letter of dismissal and then you run to the Office of the Labor Commissioner. So if you just run there, then the Labor Commissioner will not have jurisdiction to hear that matter because you have not exhausted the policies that are put in place by the employer.
Okay, well noted. Mr. Sasele, did you want to add something?
No, it's fine for now.
It's fine. Okay, so I would like to remind our viewers out there that our call lines are open, and as well as you can catch us on our social media handles where you can leave comments, as this is an interactive session, and we would like to get questions as well as queries from you. So you can find us on Facebook at the Ministry of Information and Communication Technology Namibia, as well as on our YouTube channel at MICT Namibia. Or you could inadvertently just call us directly on our line, which is 061 400 397. So you can also call us on 061 400 397, or kindly just leave your questions on our Facebook or YouTube media sites. So going to Ms. Amunyela, who bears the onus of proof in unfair dismissal cases?
Thank you very much for that question. Before I answer your question, maybe I should just briefly explain to the viewers what it is meant by the onus of proof. Now, the onus of proof is emanating from the notion of he who alleges must prove. So when a referring party refers a matter at the Office of the Labor Commissioner, that referring party is placed with an obligation or a duty to establish or present a certain amount of evidence in order to meet the legal requirements to establish their entitlement or their claim. So what does that mean? For example, if an employer refers a matter against an employee, and then the claim is that the employee maybe did not give notice and terminated their employment contract, and they didn't notify the employer. So it is for the employer to prove on certain amount of evidence in order to prove their claim. So that's what is in a nutshell meant by the onus of proof. So going back to your question on who bears the onus of proof in unfair dismissal cases, we have Section 33 of the Labour Act, which is the provision that provides that what constitutes an unfair dismissal. But that same provision further provides that in order for one to refer a matter of unfair dismissal, the employee should actually establish the existence of the dismissal. So the provision states that unless the contrary is proved by the employer, that there is a dismissal, the dismissal is constituted as an unfair. That's why we say that the onus now shifts from the employee to the employer, to say that the employer is the one that bears the onus of proving unfair dismissal cases. So why is it now important for an employee to first establish the existence of a dismissal? Like Mr. Sasele here explained that if there was an argument between an employer and his supervisor, or the boss or the supervisor, and he says go home, does that now warrant a dismissal? Is it now that the employee must run to our office of the Labour Commissioner and come and refer a matter of unfair dismissal? So no, there is a duty or an obligation on that employee to first go back to the employer and say, whether it's the next day or after the same day, and say, okay, I'm back at work. What happened yesterday? Am I fired, or what's the way forward? And if I'm fired, can you reduce it to writing? Because in the cases that we usually receive, the employer would usually raise a preliminary issue. That preliminary issue would be that, no, Madam Arbitrator, I was surprised that I was actually called at the office of the Labour Commissioner because I have not dismissed this employee, so I don't understand what am I doing here. So that's why it's important for employees to first establish the existence of the dismissal, and then only the onus shifts to the employer to prove on the balance of probabilities that the dismissal of the employee was both substantively and procedurally fair. By substantive fairness, we mean that there was a valid and fair reason for the sanction, which is the dismissal. And then for the procedural fairness, we're talking about a recognized and fair process took place. Usually in misconduct cases, that would be a disciplinary hearing. So once it is presumed that there was indeed a dismissal, and that's when we can proceed for arbitration and hear the matter on the merits of the case. But once it is not presumed, or once the employee has not established the existence of that dismissal, this may dispose of the entire matter without even going to the merits of the case. So it's very important for the employee to first establish that there's an existence of the dismissal, and then the onus of proof, or the burden of proof, now shifts to the employer to prove that the dismissal was both substantively and procedurally fair. So this also means that once we proceed to arbitration proceedings, the employer would have to present their case first and prove their case on a balance of probabilities.
Okay, well noted. So we do have a caller on the line, anytime from Windhoek. Welcome.
Yeah, from Tumeb.
Oh, from Tumeb, anytime from Tumeb. So what question would you like to ask us?
Yeah, my question is just is related to what the arbitrator has indicated.
Yes.
And that was my question before I listened.
Okay.
Yes.
So your question has been answered?
Yeah. No, I want to find out from the representatives from the Ministry of Labour. The establishment of the dismissal of the employees. These are the disputes that are dominating on in the printed media, especially on the People's Parliament program, the open line living on the local radio stations. The employees may establish the dismissal to the officer there. Particularly, I can give you an example in Katima. There were cases whereby employees were dismissed unfairly in Shoprite, and some of the dismissals were being registered at the office of labor in Katima. And generally, if people listen to this concern of mine, it has been an alarming issue on People's Parliament. It seems the Minister of Labor, especially in the branches, they are not doing enough to stand in for the employees. Now, I want to find out why is it that one may register the establishment of the dismissal, but the ones in the office are not attending to those disputes.
Okay.
That is my question.
Just to confirm, you'd like to find out why, once a dispute is registered, why the cases are not worked on?
Yes, they are not worked on, especially in Katima. We know the issue of Shoprite employees who were dismissed. A number of them, even some of the employees, they are complaining daily. They are going to the Minister of the Office of the Labor, but nothing is fruitful from the office. So employees are not said rightly as they deserve.
Okay, well noted. I will pose your question to our panelists. Thank you very much, Anytime, for giving us a call today.
Thank you very much. Good day.
So would anybody like to address that question? So it's basically stating that there's certain dispute, like for example, he gave ShopRite employees in Katima Mulilo that they did bring the disputes to your office, but it seems that they have not gotten a response, or that they feel that the cases have not been worked on. Any feedback, or is it something you have to look into?
Yeah, I can start. For the users of our offices, because if a dispute is referred to the Labour Commissioner, it was supposed to be attended to until it is resolved. So if it was not resolved, I'm not quite sure what exactly is the reason why it was not concluded. If the caller feels that the matter was not concluded, that particular arbitrator has supervisors. He can escalate the matter, he can contact the supervisors of that particular arbitrator, then they will try to find out what exactly happened. Or even him, he can even contact the arbitrator, or we have administrative officers in the regions. Can contact the administrative officer, explain to the administrative officer, I have referred a dispute here, but until today it is not concluded. I believe they will give him a feedback as to why it is not concluded. But all disputes that are referred were supposed to be concluded.
Okay, well noted. Anytime, I hope you do have your answer there. It was stated that should you feel that a matter is not attended to, you are more than welcome to escalate the case to a supervisor or an administrative officer in order for you to find out what the reason exactly is that it was not attended to or concluded. So coming back to you, Ms. Amunyela, you mentioned that with unfair dismissals is he who alleges must prove. Now, when it comes to other disputes, for example, who bears the onus of proof?
All right. When I started by explaining what is meant by the onus of proof, I indicated that the onus, the party who refers the dispute is the one that carries the burden to prove, on the notion that he who alleges must prove. Now, in unfair dismissal cases, the onus now shifts to the employer to prove because of the subsection 4 of section 33, which states that unless the contrary is proved, it is presumed that the dismissal is unfair. Now, all other labor matters that we receive at our office, the burden is still on the notion of he who alleges must prove. Like Mr. Sasele has also just mentioned a few of the common cases that we received. For example, should it be of unfair discrimination, the onus now is on the party who referred the matter to come and prove on the balance of probabilities why they're saying that they were unfairly discriminated, because the employer must be placed in a position that they can answer thereto. So once they prove that they have a case and they provide or they present a certain amount of evidence to prove what they are alleging, and then the other party would then now have to rebut or give their version as to that. So it must be clear on what exactly is it that you are alleging. So that notion basically just means that he who asserts must prove and not he who denies. So like the other example that I also gave on the termination of employment, if there's a referral from the employer to the employee stating that I was not given enough notice, there's an employment relationship, there's an employment contract, however the employee terminated this contract prematurely, so that employer now is the one who must come and prove by providing evidence to state their case or to prove their claim. So it's just emanating from the notion of that person or that referring party is the one who carries the burden of proof.
Okay, understood.
Yes.
So coming back to Mrs. Hlahla, can one amend a referral form in terms of the nature of dispute?
Thanks very much for the question. The Labour Act and the rules that are subordinate to the Labour Act are silent on the issue of amending the nature of a dispute. And if you look at it, like for example, a dispute of unfair dismissal should be referred to the Labour Commissioner within 6 months, while any other dispute should be referred within 12 months. Now, for example, you have got a dispute that you referred, say, a year ago, and now you were dismissed in the process. Now, how will you be able to amend that referral? Because what the Labour Commission is having is just a dispute, for example, of unfair discrimination or unfair labor practice. But now you want to come and say, I just want to tick also a dispute of unfair dismissal. Now, what will you put there now when you are asked, indicate the date when the dispute arose? Are you now going to have 2 dates? Because obviously the dispute would not have arisen the same day. So it's better that you make a separate referral for that specific dispute, and then you can ask now for those disputes to be consolidated so that they can be heard by the same arbitrator who has got the initial referral, who is dealing with the initial dispute. That would be to the advantage of both parties, because you may find that the dismissal maybe came as a result of other things that were already there, and now in the process the employee is dismissed. Then obviously, even if there is you give it to a different arbitrator, it could be that certain things will be said in these arbitration proceedings, but will also form part of the other arbitration proceedings in a different dispute. So it's better to have them consolidated so that the arbitrator will just deal with them at once and dispose of both disputes at the same time. Even the calling of the witnesses, it will not be like a cumbersome exercise, because they will be coming to give testimony in a matter involving the same employer and the same employee, the same applicant and the same respondent.
Okay, so in short, instead of like amending a referral form, it's always better just to create a different one, as they might have different prescription dates, basically.
Yes, and the date on which the dispute happened. Yes.
Okay, as a follow-up, I think you already started touching on it. When can labor disputes be consolidated? Are there any criteria that you look at, or?
You have to make an application That is in terms of Form LC 38. You make an application to have the disputes consolidated, and then it should be accompanied by an affidavit, and you have to serve it on the other party so that the other party can oppose or not to oppose. And then the arbitrator will now make a decision whether to consolidate the disputes or not, and giving the reasons as to why he has refused to, or he has decided not to consolidate them, or has decided to consolidate them, and then inform both parties. And that decision must form part and parcel of the whole process of the file.
So going to, would you like to add on, Mr. Munyala? Yes.
All right. We must just also, just to add on when can a party consolidate a matter, it is also just, I would just like to also add on that the arbitrator is placed with powers by the Labour Act to conduct arbitration proceedings in a manner which she or he feels appropriate in order to resolve the dispute fairly and quickly. Now, based on that quickly, we at the Office of the Labour Commissioner, it's part of alternative dispute resolution. So the objectives of dispute resolution is to resolve matters expeditiously. So now if we have instances where there are many, where one party, for example, refers different disputes on the same or against the same employer, it's going to create now a delay in the proceedings, because now we have different sets of dates, or sometimes we find that other different employees who are also employed by the same employer are lodging cases based or emanating from the same course of action. So the objective of just consolidating the matters is just for a cost-effective, less cost-effective proceeding, and also to save time. Because remember, the employer is also, when the employer comes to the office, they might be represented externally where they have legal representation. So now you have different cases on different dates, and now the employer bears the cost in hearing those or being represented in those different matters. So for an expeditious resolution of the dispute and to also save costs on both parties, it is really advisable that these matters be consolidated. But they can only be consolidated if they are emanating from the same course of action or the same nature of dispute. And like Ms. Kiliki also said that it's important when it comes to the date of when the dispute arises, because now the prescription issues will come into play.
So just a follow-up question. Can an employer also request for a consolidation if there are a lot of employees, for example, who are lodging multiple disputes against them?
Yes, of course. The employer can also, like she said, that you must make the proper application on Form LC 38. So once that application is made, it's for the arbitrator to consider whether it's appropriate to have the matters consolidated. So it can be from, the application can be made by the employees or the applicants, or it can also be from the employer's side, or it can also be on the arbitrator's own accord, because the arbitrator deems it appropriate in expediting the proceedings.
Okay, well noted. Mr. Sasele, what if one cites, or would you like to add on?
Yeah, just in addition to that, it will also be best if maybe the employer makes such an application, because say for example the three of us are involved in one course of action and we got dismissed and so on, and now they refer disputes separately, but the course of action was the same. Now one case will be given to a certain arbitrator, another one to another arbitrator, the other case to another arbitrator. The likelihood is that all the three arbitrators may arrive at different decisions, yet the case, the matters that are involved emanated from the same course of action. Yeah.
Well understood. Mr. Sasele, coming back to you, what if one cites the parties wrongly? What happens in that regard?
If a party to the dispute is cited wrongly, that is not the end of the road. The referring party still have an opportunity to rectify that. There is a provision in our rules the rules for the relating to the conduct of conciliation and arbitration before the Labour Commission. It is Rule 31. If a party was wrongly cited, and we used to say these things, you know, you find like in the construction industry, for example, the workers, they even don't know who is the owner of the company. They don't know even what is the name of the company. What they know is the foreman. Sometimes even the name of the foreman, they don't know, they just say boss. So when they refer a dispute, they just put boss. When you go for a hearing, there will be an issue on citation. But it will not end there. The matter will not be dismissed by the arbitrator. The referring party will be given an opportunity to rectify that by filling in, by making an application to the arbitrator. You fill in Form LC 38, accompanied by an affidavit or a statement. If the arbitrator have allowed that, then it should be saved on the other party to the dispute. Then the application, together with proof of service, it should be brought to the office of the Labour Commissioner or to the arbitrator. Then the power is given to the arbitrator to decide whether to change the citation or not, depending on the reasons that were given. But of course, the other party to the dispute also have a right to oppose if you feel like opposing. Maybe he's not the right employer. He can still oppose. So there are forms at the office. You fill in that forms to oppose the application. If it's opposed, as I explained earlier, then the arbitrator will make a decision.
Okay, well noted. So I would like to remind our viewers that our calling lines are still open, and we do encourage you to call in and leave your comments on any of our social media handles, namely on Facebook at the Ministry of Information and Communication Technology, or on our YouTube site at MICT-Namibia. Or you can directly call us at 061 400 397. So that is 061 400 397. So going to Ms. Amunyela, can one withdraw a referral of a dispute?
Yes, any party who referred the dispute at the Office of the Labour Commissioner may withdraw the matter. This can be done prior to the commencement of the proceedings. In the event that the referring party no longer wishes to pursue the matter, or it can be done during the proceedings, during the arbitration proceedings, whereby, for example, maybe there is a material defect in the referral form. Once there's a material defect and the party wishes now to withdraw that referral, they can always withdraw it, but then the arbitrator must look into the intention of why they are withdrawing that referral. So the effect of withdrawal is just that the case is now going, or the party who referred and withdrew may also now re-lodge or refer another case, whether it's on the same nature of dispute. But the important thing here is just that we must look at the intention why the matter is being withdrawn. So, for example, parties may, prior to coming to for conciliation proceedings, they might settle the dispute amicably between themselves prior. So once they do that, they may come and withdraw the matter that they have referred. Or they may alternatively just bring the settlement agreement, and then the case or the file will be closed, because we cannot close files and just leave them there. They should be reduced to writing. And once they are reduced to writing, it's when there's a withdrawal, or once they settled prior to the proceedings, once they submit that settlement agreement. So at any stage, a party may, the referring party may withdraw the case.
Okay, well noted.
But
so
also,
kindly hold your thought. We will come back to you now. We do have a caller on the line, namely Brand from Windhoek. Welcome.
Hello.
Yes, hello.
I'm speaking from Windhoek.
Yes.
I just have three questions. Firstly, I am having a case for a company. I was unfair dismissed.
Yes.
It started in 2020, in June. And every time when the case comes, it's the labor commissioner, we come there, they postponed it like 3 to 5 months. We have to wait. Then after 5 months we come, they do a session now 2 years, and we are still waiting for this case to be finished. What can one do when you are still waiting for this matter to be resolved? And the other question is, when you appeal on your dismissal, for the first time you appeal to your company that the decision that they made was unfairly, and then they transfer the case to a legal department where a third party will do the appeal application. And the third party also said that the dismissal was a fair dismissal. And when it went to the labor commission, they said no, we have to go on with this case so that it can be proven that it's a fair dismissal. But from the second party that have done the appeal, they have given the appeal letter like written in pencil, which was not correct. So I just want to know the period and the process of waiting. Why is it taking so long for a case to be dissolved?
Okay, Brand, so you'd like to know in short why your case is taking so long and why is it being postponed so many times, and why your appeal letter was written in pencil?
Yes, from the second party who's done the appeal.
Okay. Thank you very much for the call, Brand.
Okay, thank you.
Any of you would like to tackle?
Although we are not really here to deal with individual cases, however, the issues that he has touched on are common. Yes, it is true that a case may take long when it is being postponed, due to the fact that we receive cases every day from Monday to Friday. And in a week, we receive about 100 cases in a week. And now, when your case is given a date, one should ask himself or herself, why is my case not taking place? Because sometimes parties do come asking for postponements. When you ask for postponements, you will find already cases that came after your case also given new dates. That's why you will find your case will be given the next available date. It is not like it's a deliberate issue to say we are punishing you, your case will only be heard in December or so on. But what I want to stress here is that once you are given a date to appear for your case, please commit and make sure that your case is heard, unless maybe you are not the one occasioning the postponement. Because some of the postponement, a person will tell you, I didn't have money to travel, and now please postpone my case. But you knew all along that you had a case, and you did not even notify the parties well in time, so that if you notify them well in time, the matter may be postponed to an earlier date if there is the nearest available date. But if you come, you wait on the date of the hearing is when you are saying, please, I'm sending somebody to come and postpone on my behalf, then it won't be okay. Because the postponements are also causing havoc, they are also causing, a backlog to our system. And we may, to the public, we may appear as if we are not doing our work, but some of those postponements are not occasioned by the arbitrators. Arbitrator may postpone a case maybe if the arbitrator is sick or has got a death in the family, but just on his or her own to say I'm postponing the case, then it is not a problem, because the supervisor will also not be okay with it.
Yes. So it's basically, it's not up to the arbitrator to postpone the cases, but when the cases are postponed, it's either because of one of the two parties cannot attend, basically.
Sometimes they even agree. the representatives may agree to say, yes, let us postpone the case. And then when they postpone the case, later on they start complaining to say, why now it's in December or in January next year?
Okay.
Because the new cases, they are also, they are not waiting.
Okay.
Yeah, so it's just to encourage them, they should try to attend to cases when they are given dates.
Okay, well noted. So we do have another caller on the line.
The other, oh, okay.
If we can just hold, and then we can continue. Welcome, caller.
Yes.
Yes. How are you, Mr. Lister?
I'm all right. How are you?
I'm fine, thank you. What is your question for today?
Yeah, my question for today, I don't know because I found this program already. I just wanted to ask two questions.
Yes.
One is the issue of I have appealed at the company level. So, but the company did not reply to my appeal. Maybe a month or so, then I referred the matter at labor. Can the Ministry of the Office of the Labor Commissioner dismiss such a case, or how? If there is evidence that I did appeal at the company policy, but the company did not follow its own policy to give me an opportunity to hear my case. That is one. The second one is somehow like a comment. The Office of the Labor Commissioner is like so ineffective, because you find out that, for example, the case was heard. Maybe I have a practical case which was heard, the arguments, which was the heads of arguments submitted in March, only to get an outcome last week, almost 5 months waiting. So why the Office of the Labor Commissioner so ineffective? So the last one, I don't know whether it was already asked this one, is we want to know when the dispute arose. Is it when you were dismissed, or you wait until the appeal is being done? That's when that will be now the date of the dispute, or how? Thank you very much.
Okay, well noted, Mr. Lister. Thank you very much for your call. So we can start with his last question, as it's much simpler. So when exactly does a dispute arise?
Okay, maybe we didn't do justice to the other
previous
question
one.
of the
Okay,
first
we can
caller,
just continue then.
where the first caller said the appeal chairperson of a disciplinary hearing wrote in a pencil.
Okay.
So we wouldn't have an answer to that, because he can bring it up. He can argue about it to say why, or ask why it is written in a pencil, or if there is a case, then he can bring it to the table, and then when both parties are there, and then it can be argued on, and the arbitrator will take a decision based on the evidence adduced before the arbitrator. Okay, you were saying the last question to say,
when does a dispute arise?
there is a court case. I would just like to refer to it, and then if you may allow me, I can read.
Yeah, okay, we can do so quickly.
Then it was in the matter between National Disability Council of Namibia, where the Labour Court held that internal remedies available to the employees must be exhausted before a dispute is referred to the Office of the Labour Commissioner. And it went further to say an arbitrator has no jurisdiction to hear the dispute until and unless internal remedies have been exhausted. This is now a court that is higher than us, the Labour Court. So when the Labour Court has passed a judgment, we are bound to follow that judgment.
Okay, in Mr. Lister's case, what he was asking is, he did appeal, or he did go back to his company, but they still have not responded to him.
So if then they have not yet responded to him, then it means the internal processes have not yet been exhausted.
Understood.
Yes, and also to mention, to say that each case is being dealt with on its own merits, and that's why we may not discuss individual cases here, because we just don't hear one side of the story and make conclusions. That's why with our process, both parties will be called to the table and each party will be stating its side of the story, and then the arbitrator will now analyze the evidence adduced before him or her and the closing arguments and then make a decision.
Okay. So I will give each of you a minute for your final remarks. You can close up on any other thoughts that you previously didn't finish.
I just wanted to on the
okay,
appeal.
Ms. Amunyela, you're more than welcome.
Yes, just to also add on the appeal question. So once the caller indicated that he has not received the appeal outcome yet. So the caller would also have a duty or an obligation to follow up with the employer why such appeal outcome has not been furnished. It might be internally that the chairperson, there can be instances where the chairperson has not finalized the matter. There can be instances where the chairperson was sick. So the duty is basically on the employee to also follow up with their employer why it's taking so long. Because they might have their own policies internally that says that a disciplinary, an appeal outcome can be furnished after a certain period of time. So before coming or lodging a case at our office, the duty is on the employee to first find out internally why the matter or why the appeal outcome has not been furnished.
Okay, well noted. Mr. Sesele, final thoughts?
I would just like to comment in addition of what my colleague was, she was saying something about withdrawal of labor disputes. You know, it is very important that if a matter is withdrawn, the party that is withdrawing the matter should indicate the reason in the withdrawal to avoid further disputes. Because generally, if a dispute is withdrawn, it was not supposed to be referred back again. But if there were some reasons, good reasons why it was withdrawn, it can be referred. But if in the withdrawal letter it is silent, then the respondent will say, no, but we have already withdrawn the dispute. Why again are you bringing it here?
Okay, well noted. Mrs. Sislahla, any final thoughts?
It is just very important that we should understand that having an issue, it does not mean a dispute has developed. You must show the steps that you have taken now for you to say, I have tried ABC and ABC, and I think there is no, I don't have any other option, and the Office of the Labor Commissioner or the Labor Commissioner is my last resort. Like what the caller said, that is an appeal with the company. What prevents you from following up, as Ms. Amunyela has indicated? Follow up, because if you come, the Form LC21, it requires the referring party to indicate.
No, you can finish your thought.
To indicate the steps taken before referring a dispute.
Okay. So thank you very much, Ms. Amunyela, Mr. Sasele, Mrs. Lahla, for joining us in studio today. So we would like to remind our viewers, for those of you who missed our show on Monday, the 15th of August, that our Heroes Day logo was unveiled by our Executive Director, Dr. Audrey Mate, of the Ministry of Information, Communication and Technology. So I'd like to just inform you about the meaning behind the logo again. So the meaning behind the logo is that the flag symbolizing peace, unity, and common loyalty to the Namibian state. It also features the eternal flame that symbolizes the nation's eternal remembrance of the sacrifices of our heroes and heroines and our perpetual gratitude to them, and in memory of our war victims. Finally, the three soldiers represent our armed struggles for independence. With that said, my name is Angela Situmbeko, and from me and the production crew, have a lovely day ahead.